I'd like to call to order first the Town of Belleville Planning Board meeting for May 20th, 2024. Just procedural things, so just bear with me. What we'll need to do in this is nominate Chris Seberg as the Secretary of the Planning Board. And then we can adjourn this meeting until the conclusion of the Board of Adjustment hearing. It's a procedural thing. So can somebody nominate Chris Seberg as Secretary of the Planning Board?
I nominate Chris Seberg, Secretary of the Planning Board.
Do we have a second?
I second.
All those in favor say aye.
Aye.
You want to call the roll now, Chris, or later?
Yeah, we can do that when we convene as planning board. Okay, so, Ethan Barker.
Here.
Ty Cannon.
Here.
Kitty Sullivan.
Here.
Susan Manette.
Here.
Andrea Beasley.
Here.
Jim Dubovic.
Here.
Chad has a wonderful excuse for not being here. It's called a wedding anniversary. I think that's valid. So
I make a motion to excuse Chad from the meeting tonight.
I second.
all those in favor say aye.
Aye.
Thank you. Now I'd like to recess the planning board until.
Mr. Chair? Mr. Chair, before you recess, as your job as chair tonight is to appoint the Board of Adjustment, the 5 members of the Board of Adjustment. So
Do it now?
Yes, sir. We need to do that before we go into the Board of Adjustment meeting, and you need to appoint 2 alternates. And I know you have 1 member not here tonight. Just let me remind the board, if I may, that you have to have 5 members of the Board of Adjustment for a quorum. So if you appoint the absent member as one of the board members, you will not have a quorum for the Board of Adjustment meeting, and you'll need to
I understand.
change that. Table it.
Okay, with that said, before I nominate voting members, are there any members here that have had ex parte communication, any bias or conflicts of interest with the subject of the Board of Adjustment hearing? Okay.
No, sir.
With that said, anybody want to excuse themselves? Okay.
Nope.
I've got to decide to sit one of you out. I'm sorry about this. And I'm going to do it in the most fair way I think I can. The newest member, I think it would be appropriate, and I hate to ask you this, but you'll need to move from behind the dais. But pay attention in case you got to come back for,
Mr. Chair, they make us stay until you make the motion to adjourn the planning. board.
okay, you can stay till it. Listen to her, she's an attorney. They just give me a toy hammer. Okay. With that said, is it time to recess?
It's time for, okay, so you've appointed everyone except Ms. Beasley and Mr. Dubovic.
Yes, everybody, the other
Oh,
5.
no, except for,
Dubovic
And
and
Chad.
Chad.
Okay.
Yes, ma'am.
got it.
The other 5 up here are the appointed voting members of the Board of Adjustment. 5. 1, 2, 3, 4, 5. I get to vote in this one.
Yep.
And that's just by appointment. No vote is needed on that.
Okay.
Right, okay.
Do you need now a motion to adjourn?
Motion to recess.
Sorry, thank you, sir.
I make a motion to
Recess
recess
until after the Board of Adjustment.
until after the Board of Adjustment meeting.
I second.
All those in favor say aye.
Aye.
Passed. Okay. Now, with that procedure done, let's do it all over again. Planning board agenda to the side. Okay, I'd like to call to order the Town of Emerald Isle Board of Adjustment meeting, May 20th, 2024. Roll. Will you call the roll?
So roll call, Ethan Parker.
Here.
Ty Cannon.
Here.
Kitty Sullivan.
Here.
Susan Manette.
Here.
Andrea Beasley.
Here.
5 present.
Alternate,
We have
Jim Dubovic.
6 present, but we got our 5 voting members. Okay.
Mr. Chair, you take up the matter of the secretary. Would it be appropriate before moving forward?
Yes, it would. We need to nominate a secretary for the Board of Adjustment like we did for the Planning Board. And Chris Seberg is the perfect man for the job.
Agreed. Perfect.
You want to make a make a motion?
I make a motion that we accept, or we go with Chris Seaberg as our secretary for the Board of Adjustment.
Perfect.
I second the motion.
All those in favor say aye.
Aye.
Okay, this is an evidentiary hearing.
Mr. Chair, I'm sorry. The public hearing needs to be held before the evidentiary hearing. So if this board will make a motion to go into public hearing, we'll see if anybody has signed up for public comment. Have you checked that, Mr. Secretary?
There were none on the list when I looked at it.
Okay.
Is there anybody here to speak about?
Still need a motion to go into public hearing.
I'll make a motion to go into public hearing for the review request for the variance application.
Do we have a second?
I second.
All those in favor say aye.
Aye.
Okay. We're in a public hearing. Is there anybody here that wishes to speak?
So, Mr. Chair, I have Katie Poole and Mr. Brent Quick, who's the applicant, but I think that you all, I don't want to speak for you, if you want to testify quasi judiciary, you're a party in this case. So this is just a public comment, or anybody who comes to anything, so is it appropriate to remove you from this list and just have you testify at quasi judiciary? It's your party. Okay. So we don't have anyone for public hearing,
Okay.
Mr. Chair.
Like, a motion to
I'll
close.
make a motion to close.
I second.
All those in favor say aye.
Aye.
Public hearing is closed. Okay, Chris, if it's okay with you, I'm going to drop down to 3, which is the clerk or chair administers oath to applicant and any other party who may testify or offer evidence.
Okay.
And I'll be administering oaths for the secretary.
Oh,
Anybody else, I know you two are testifying, anybody else testifying on this case? Not to my knowledge.
And the chair will need to swear you as a witness.
Well, excuse me, you're attorney. I need to swear you in. Someone swear or affirm to tell the truth, all the truth, and nothing but the truth.
I'd like to swear in our secretary. Do you swear to tell the truth, the whole truth, and nothing but the truth? Judge.
And you're swearing him secretary and a witness in this matter? You got it. Swear, you're, just for the record, you're swearing him in as secretary and also as a witness
Yes.
in this matter. Thank you, sir.
Okay. Okay. I've got a statement to read about this type of hearing. Bear with me. This hearing is a quasi-judicial evidentiary hearing. That means it's like a court. State law sets specific procedures and rules concerning how this board must make its decision. The board must base its decision upon competent material and substantial evidence in the record. In its decision constrained by the standards in this ordinance and based on the facts presented, all applicants for variances must be consistent with the Emerald Isle Unified Development Ordinance. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. Participation is limited. This meeting is open to the public. Everyone is welcome to watch. Parties withstanding have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to those individuals withstanding as set forth in North Carolina General Statutes 160D-406 and 160D-1402. Other witnesses may present competent materials and substantial evidence that is not repetitive, as allowed by the board. For certain topics, the board may hear opinion testimony from expert witnesses. Individuals providing expert opinions must be qualified as experts and provide factual evidence upon which they base their expert opinion. Witnesses must swear or affirm their testimony. At this time, we will administer the oath for all individuals who intend to provide witness testimony. Anybody here going to provide witness testimony? Okay, we can. There's no question about standing over the board members. Is that correct? Okay. Next item, staff presents an overview of the case and formally enters preliminary materials into record. Chris, Mr. Secretary?
Mr. Chair? Greg, if you could put the presentation on the screen. Okay, we got various case number 24-001, physical address of 1310 Emerald Drive. And the variance request is of section 5.1 of Emerald Isle Development Unified Development Ordinance. If granted, the variance would allow for the replacement of decking and access and front yard of 1310 Emerald Drive to adhere to a 14-foot front yard setback versus the minimum 30-foot front yard setback. Case history on this: on April 9th, 2024, Mr. Quick submitted a development application to remove and replace the existing deck for the structure at 1310 Emerald Drive. I'll show you Exhibit 1 in a minute. Mr. Quick was notified via email by Greg Hayes, Assistant Town Planner, expressing concerns with the location of the existing deck with the code requirements of front yard setbacks, which is included in Exhibit 2. Town Customer Service Representative Tony Seminary documented in an email that Mr. Quick informed him over the phone on April 11th, 2024, that the stairs and decking were removed as part of Exhibit 3. Both actions occurred without any permit being issued by the town. So you see on the screen, Exhibit 1 is the permit application. Exhibit 2 is email correspondence from Mr. Hayes to Mr. Quick, along with screenshots of GIS showing how the mapping system shows the location of the house and the measurements of 30 feet. You'll see that faint blue line. And then on Exhibit 3 is the email correspondence from our customer service rep, just documenting the phone call that he received. Continuing on case history, on April 12, 2024, Mr. Hayes received an email from attorney Kathleen Coyle, representing Mr. Quick, arguing that the deck should be permitted, and that is part of Exhibit 4. On April 15th, Town Planning Director, myself, Chris Seberg, answered Mr. Coyle's email as answers in Exhibit 5. That April 15th email documented specific portions of town code relevant to Mr. Quick's project. The email also stated that the town manager, Matt Zapp, and the planning director made a site visit to verify measurements from the right-of-way of NC Highway 58, also known as Emerald Drive, measuring from a concrete right-of-way marker that's located on the corner of Highway 55, also known as Emerald Drive, and Raleigh Street. The front line of the house, not including any portion of the footprint of the previous stairs or deck, was exactly 30 feet. And again, Exhibit 4, that's the email received by Mr. Hayes. And then attachments provided included the text cards and then the photo from the text card, historical GIS map, a copy of the application submitted, a copy of the original subdivision plat that did include this lot, and then the aerial photography off of GIS, county GIS system. Exhibit 5 is the answer, giving out the specific code references for this project. Site visit photos showing the deck already removed, the piers in there, and then also the picture from Raleigh Avenue. Continuing with case history, On April 23rd, Mr. Quick did submit an application for this variance, and it's included on Exhibit 6. And the specific request was for Section 5.1 of the Emerald Isle Unified Development Ordinance. Here's Exhibit 6 in full. That second page of Exhibit 6 are some additional information provided to answer the questions for requesting the variance. So Exhibit 7 is straight from our code. The focus you'll need to do is over there on page 2. I don't know, yeah, over here. That's the specific that has the Front Street right-of-way requirements. Continue with case history. Section 2.3.5 in Emerald Isle Unified Development Ordinance requires staff to publish notice of the public hearing in the newspaper at least 10 days and not more than 25 days prior to the hearing. The notice must be circulated once a week for 2 consecutive weeks. Notice of the public hearing was published on May 8th and May 15th editions of the Carteret News Times. The proof. Continuing with case history, Section 2.2.3, subsection 4, subsection B of the Emerald Isle Unified Development Ordinance requires town staff to notify applicant and applicant or adjacent property owners via USPS first-class mail to the mailing addresses documented in the Carteret County tax records, accessed through, and that's the county's website for the GIS system. The notices were drafted and mailed on May 2nd and are included as Exhibit 9. So that's the certification of delivery, copies of each of the notifications, including the applicant. Let's see, continuing on Section 2.3.5, subsection 4, the Emerald Isle Unified Development Ordinance requires a posted notice on both the property in which the applicant is pertaining to the normal meeting posting of the town's review. A town public notice sign was placed on the property at 1310 Emerald Drive on May 1st, 2024. The public notice of the hearing was posted not only here at the Emerald Isle meeting room on the 13th of May, but also at the administration building on the 13th of May. So after all individuals present to provide evidence in this application have been administered an oath, the board can hear the presentation. When receiving testimony, this is the important part, when receiving testimony on a variance, the board shall be cautious on the following. Hearsay evidence is not generally allowed. Opinion evidence generally should be offered only by properly qualified expert witness. And then number 3, there must be substantial, competent, and material evidence to support each critical function. And then, of course, A, B, C, and D are the requirements that this board would have to answer when considering a variance. If you're going to grant a variance, it has to be by a 4/5 vote. And then finally, if there's a appeal of the decision of this board, it goes to the Superior Court of North Carolina, not the Board of Commissioners. That's all I have.
I've got one quick question.
Yes, sir.
On the site visit, I noticed on the Raleigh side, the number's 1308 on the house. Is that the address, mailing address, different than the parcel address?
So I believe it's a duplex style where maybe the upstairs is one residence and the downstairs is another. So yeah, that's.
But it's the same building? Just
Same
to
building, yes,
clarify
sir.
it. Okay.
That is correct.
Any questions for the secretary? Okay, are you done, Mr. Secretary?
Yes, sir.
Okay. The next, the applicant presents his or her case. And yes, ma'am. Step to the podium, give us your name.
Hi, I'm Kathleen Coyle. Most people call me Katie, though. I'm the attorney. I'm with Howard Stallings Law Firm, and I'm the attorney for Mr. Brent Quick and the Quick family. I wanted to give you, I'm going to let Mr. Quick give some information about this, but I wanted to give you an overview from our point of view. And so this is a home that was built in 1973. The deck was built in 1973 as well. The deck has always been a part of the house, and that's actually how you reach the front door. There's no way to get to the front door unless you have that deck there. The deck has, since it's been there since 1973, was in pretty bad condition. So, and was unsafe, and Mr. Quick wanted to repair it and actually wanted to replace it, which is why he submitted a permit. I wanted to touch on that thing. I know it's not part of this, but I don't want it to color your perception of this case. He had submitted for a permit and then went to, he's going to tell you more about this. He went to try to do some in the jury rigged kind of thing. In the meantime, kind of make the deck a little bit safer, and it collapsed. So he didn't mean to take it down. It just collapsed. And then there was a misunderstanding with his contractor as far as going ahead and starting to work on it. And when he realized his contractor had started to do that, he stopped him. So I just wanted to let you know the explanation about that. So we first tried to have the planning board understand that we thought this was a non-conforming structure case where Mr. Quick could replace the deck so long as he stayed within the same footprint, and it wouldn't be a problem. Because, as I said, the house has been there since 1973, the deck has been there since 1973, and he just wanted to put up the same thing. But Mr. Seberg and the other folks wanted to do a strict interpretation of the ordinance there, and did not feel that this was the type of circumstances, the destruction, how the deck just collapsed was not the kind of situation where you could take advantage of this non-conforming structure ordinance to rebuild within the same footprint. We still don't agree with that decision, but we decided to go ahead and ask for a variance because this clearly meets all the requirements that are supposed to be shown for a variance. I don't know if y'all had a chance to read okay. So I'm not going to read through it, but it's a strict application of the ordinance would create an unnecessary physical hardship because you won't be able to get through the front door of the house. It's just not, and it looks just frankly absurd, weird to have a front door in the middle of the house that you can't reach. It's also unsafe. If anybody wants to, they would have to, I don't know what they would have to do to keep anybody from walking out the front door and falling from a second story. The hardship results from conditions that are particular to this property. It's always been this way. This is, when they were built, we assume they were built in accordance with whatever kind of ordinances were in place at that time, if any. And I do want to point out that we included an attachment of the original plat because the original plat has has 30 feet more showing on it than the current GIS measurements for the lot. So at some point, I assume probably the highway came along, the DOT came along and widened the road. So initially, this most likely did meet even today's standards for the 30-foot setback. And the hardship does not result from actions that Mr. Quick took. It's been, he's had this family since, he's had this home and his family since the mid-1980s. And it's always been this way again. They've tried to keep the deck up, but it's, we're on the coast, 51 years of wind, rain, flood. There's only so much you can do. We think that the requested variance is consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. Replacing this deck is going to make it safe for both the inhabitants, their visitors, delivery people, the mailman, whoever, to get to the front door of this home. It's going to beautify the neighborhood. Right now, you've got a house that's got no deck up to its front door, and it's just strange. Not having the deck is decreasing the value of the home, and it's most likely decreasing the value of the neighboring homes. On top of that, we wanted to mention that the Quick family went out and measured today and believe that it is actually meets the setback, the post for the deck, and think that maybe where the right-of-way marker that was measured from is not the correct one. And we don't have a survey. We can't say for sure, but it certainly looks like it would still meet the 30-foot setback if it's measured from the proper post. They also went and looked at did some measurements around for some neighboring properties. It looks like variances must have been granted in the past for some neighboring properties because they have structures that are closer than Mr. Quick's. And finally, Mr. Quick's neighbor recently had very significant renovations done to his home, and his home, the neighboring home, definitely doesn't meet the side yard setback, so we assume a variance was granted for them. So in the sense of fairness, we think it would be a good idea to go ahead and grant Mr. Quick his variance. Fairness, and safety, and making the neighborhood look better. I'm going to let Mr. Quick speak. I didn't realize this was going to be so formal. I wasn't planning on asking him questions. I was going to let him just sort of tell his story. And I think, though he's not an expert, I think he's allowed to give an opinion about his property, his own property. And so I think he can give you some background, his history with Emerald Isle, and flesh out what I've told you with some more facts. Brent, you want to come up?
Ms. Coyle,
Yes, sir.
I do have one question for you.
Yes.
You said you measured from somewhere else, and you think it meets the setback?
Yeah, Mr. Quick can respond to
Okay.
that.
Now, the town had asked for a survey sometime in April, and it was never provided.
We don't have a survey.
Why not?
We haven't had one done. And then this, surveys also cost money. We thought until today, when they went to, had the idea, well, what are they talking about? What are they measuring? We figured out that maybe y'all weren't measuring from the correct post. And we could be wrong. We don't think we are. We could be wrong. And yes, a survey could help figure that out. But
It was figured out, definitely.
Yes,
Had a survey.
a survey would end the discussion on which survey right-of-way marker was measured from. I think the specifics of the case are 100% per, the only discussion is, are you encroaching the setback or not? If we don't know where the setback line is in relation to your project, how can we competently make a motion, so we don't know if it's 1 foot in or 20 foot.
Well,
we need a
y'all
survey.
denied the permit, so.
We did not, no ma'am, it was the planning staff. And for us to review this variance, I would think we would need a survey to see if we are in fact needing a variance, and if we are needing a variance, how many feet inside the DOT, inside the 30-foot setback from the DOT right-of-way that we are.
We can't assume that where you measured from is more accurate than where town staff measured from. That's
So-
why the survey was requested.
Well, you didn't request a survey. You said that was an option. And at the time, surveys cost money. It looked like the variance path, why don't we just go ahead and, at that point, we were assuming that they had the correct measurements. So let's go this path of asking a variance. If we don't get a survey, you're saying are you saying that we have to get a survey before you'll even consider
Make your
our
claim-
variance
Make your claim
request?
evidence that the town staff measured wrong, you would need to have that survey. You can't say, I think, and that's not evidence.
an opinion.
That's an opinion.
Well, that's why we're asking for a variance. Let's assume that the town measured it correctly, okay? I'm throwing this out there because I wanted to let y'all know that. But let's assume that the town measured it correctly. We're asking for a variance.
You're asking for a variance of, I think, 14 feet, is that correct?
16 feet,
16.
that'd be 14
That's-
feet off of the building.
If you're saying, there's a big difference between asking for 16 feet versus asking for 2 or 3 feet. And if you're saying that the measurement is wrong, you're more likely to get more of what you want if you have a survey to show that. You can't say, we think that's where it is, and say, we just want an open-ended variance.
Well, let's let Mr. Quick speak to you a little bit, and then, we may
Okay.
be able to go ahead and do that.
You have to forgive me, this is my first time at an event like this. I am a government employee and familiar with Robert's rules, but
Can you
this
state
is
your
new to
name,
me.
please?
Is it okay if I approach you and we give you some pictures to view?
State your name for the record,
My name is James Brent Quick.
and you're the property owner.
Yes, sir, 1310 Emerald Drive.
Okay.
I reside in Wake County full-time and have a home on the island that we've owned since 1986. These photos are in order, ma'am. If you would just share them and pass them down. On or around April 5, Friday, we took down to the beach to make some repairs to the deck. So please understand, at no point in time was it our mission to have the deck collapse. If you can see by the first photo, there were 4x4 posts that were bowed, and they were unsatisfactory to support the load. The deck has been on the home and been repaired numerous times since 1973. I can tell you since we took it over fall of '86, we've made numerous repairs to it, from deck sealants to replacing floorboards, handrails numerous times, stairs on multiple occasions, and that got us to this point. The goal was to raise the deck and support it, remove the damaged and substandard poles, and install new posts which would run up through the substructure, and we could attach handrails for safety purposes. I am fortunate enough to have a new grandson, and I wanted the home to be safe. This deck has been an integral part of this home since we've owned it. The Town of Emerald Isle Fire Department has gone down and actually carried my uncle up the stairs before he passed away with cancer. It was the last thing he wanted to do. Now, that wouldn't have been possible without the use of this deck. In the process of repairing it, we tried to raise the deck up to remove the poles. When that happened, the deck suffered a catastrophic failure. broke completely in half. I did not get pictures of the deck piled up on the ground because, as you can see, there's a picture of a water line. It sheared the water line off and water was spraying. So had to make an emergency water repair, called local company, got a can, loaded up with scrap to make it safe because there was broken debris, wood, very unsightly and very unsafe on the property. Deck was cleared, removed, application was applied for Monday or Tuesday. I think Mr. Seabrooks got it on the 9th, which was the Tuesday. And I also applied for one with Carteret County. Was told that's what I needed to do. Now, fast forward, my wife owns a masonry company, and please forgive me, I'm not trying to be racist. She has Latinos that work for her. They were working down in this part of the state, and we had talked about the possibility of putting some columns up, brick columns, block columns, possibility of stucco, maybe stone, just something we could do to increase the curb appeal. And any repairs that I make, I try to modify the home, metal roof example, vinyl windows, for instance. Try to do something to where it's the last time I have to do that project before I pass away. The deck was another thing. The groundskeeper, yard man, lawn maintenance person tends to weed eat, trim, grind the corners of the post, and it suffers significant damage, just like it does on the vinyl. So going with the concrete option was what we talked about. Something got lost in translation when I said I had applied for the permit with the town of Emerald Isle and with Carteret County. The guys had a cancellation. They drove down unbeknownst to me. They've actually been down and visited us, so they knew where the home was. They promptly put up columns, put in rebar, said they knew exactly what they were doing, and they took it upon themselves to begin work. Once I found out that had happened and there was an issue with the permit, I stopped. Called them off, ceased, and if you ride by my house right now, you'll see piles of mortar and block and everything else in the front yard, and you'll see 5 columns. Never was the intent to do anything without a permit. Some things became reactionary instead of proactionary. The deck's been part of the home, curb appeal wise, and it's served its purpose. It had reached its end of life, as we found out when we tried to make these necessary repairs. Now, I will clear one thing up. We talked about it being an exact same footprint. The original paperwork shows the deck to be 20 by 16, and that is accurate. But that included the stairs coming all the way down the front, facing the house from right to left. Due to current code, we weren't allowed to do that. We would have to come down to a landing midway and then turn and egress the rest of the way down. For that purpose, we chose to move the stairs over to the left side facing the house. Now, that is the only variation up to the footprint that would be affected, but it would not be further out into the right-of-way, setback, or the concerned area that we're here discussing tonight. I have not been back down here. I've tried to have no contact with anyone, hadn't reached out. We came down today for this meeting, and I decided to go by and look at it, and I did pull some measurements. I'm not an expert by any means, nor do I claim to, but I think, my opinion, we measured the distance from the center of 58 Highway, Emerald Drive, that we already discussed, to my deck. Now, I didn't measure from the right-of-way marker. There is one at Raleigh Street, and there's another one up on the next street up on the right. I'm not sure, opposite Mr. Wheeler's house on the other side of 1312. Now, you can clearly see that those right-of-way markers are in a line. There is another marker in Mr. Wheeler's yard, which I know Bobby, as long as we've owned the house, we've known the Wheelers. Short version, we won't go into that, but the distance is about 29 feet. I'm sorry, it's 39 feet from the center of the road to that right-of-way marker. Now, I'm not going on setbacks, I'm not going on right-of-ways, but what we did is pull a tape measure from the center of 58 to the corner of my deck. On the left side, the corner post is 60 feet, 4 inches. On the right side, it is 58.7 something. So it's right there. The angle of the house is a few degrees from being parallel to the street. So therefore, the right side would be closer. So to finalize where we are right now, I would like to say that as a taxpayer and as a long-term resident of Emerald Isle, we've invited friends down, we've sold homes, we have family that come here, and we have family that lives here. And I feel like a victim. I'm not trying to create the Deck Mahal. I'm not trying to embellish or overstep my grounds. I'm trying to improve the curb appeal, improve safety for town residents or visitors that come to my property as well as my family. And I'm trying to bring it up to current code and do the right thing. So never an intent to circumvent, always trying to be above board. Applied for a Carteret County permit and it was accepted. I've got a copy of it in this folder from Carteret County. No work has been done, waiting for this event to happen. And I came here to discuss this and plead with you to have some understanding and some leeway to allow us to restore the use of my home. Thank you.
I have a question for you.
Yes,
quick. By improving the deck, the original option that you were trying to do, did you hire a contractor to do that, a licensed contractor?
No,
Or you
sir, I
it
did not.
Okay.
No, sir, we took it upon ourselves, thinking that if it wasn't going to be something that was attached to the home, it was just putting some poles in. I'm pretty handy, not saying I'm a contractor by any means, but, you know, the goal was to just replace the poles, stand them up, bury them in concrete, and secure the deck.
Did you apply for a building permit prior to that with the county?
No, sir, I did not. Once I talked to the county, they told me I could make minimal repairs.
Any, the way I say that, the reason I say that is any structural improvement to any structure in North Carolina requires a building permit. And poles supporting the deck would definitely be structural.
When I called about the permit, sir, and forgive me, I don't know who I spoke with at Carteret County, they said if I was making repairs, we didn't specify structural, but if I was making repairs, I didn't need a permit. Said if you're going to completely refloor or rebuild the flooring system, one would be required. So no, I did not apply for a permit at that time. There is one issued now. I'll be glad to provide that to you if you'd like to see it.
By whom?
Carteret County, sir.
Okay.
Would you like to see a copy of it?
I don't, does it have any bearing on this?
It's for the board to determine. You're welcome to take a look at it, Mr. Chair. And
Okay.
determine
Yeah.
whether
No, that's two
it
different,
has
that's two
bearing.
different things.
You're all-
Because that's building versus.
We'll take a look at it.
May I approach, sir?
Yes.
And Mr. Quick, Ms. Coyle, do you want to ask the board to admit your photographs and evidence as well?
Yes, please.
Do we need to vote on that?
Yes, sir, well, that decision is up to you.
I'm talking about the photos.
Yes, sir, that decision's up to you as to whether to admit the evidence.
I don't.
I make the motion to admit the pictures into evidence.
I'll
for
second that.
the case.
All those in favor say aye.
Aye.
We accept the pictures submitted by Mr. Quick as evidence in the hearing. On this permit application, it's estimated cost $12,000.
Yes, sir.
That's not minor repairs.
No, sir, that was after the collapse of the
Okay.
original deck.
Okay.
Again, a permit was not required, or I was told one was not required for minimal repairs.
Okay. I just
That's
wanna
for
make
total
sure- I
replacement.
just want to make sure that,
Yes, sir, that application was submitted the exact same time I sent the one to Emerald Isle, same day.
okay, and that's from Carteret County, not from Emerald Isle.
Yes, sir, I submitted both, one for Carteret County and one for Emerald Isle, the same day.
You want that entered as evidence as well?
Yes, sir,
Okay.
please.
You don't want it back? Or you want?
I have a copy.
Okay.
Not a problem, sir.
Do we have a motion to enter the county application into evidence?
Yeah.
Make a motion to enter the application, the county application as evidence.
Do we have a second?
I'll second it.
This is signed
Not signed?
by him.
Okay. If it's unsigned, it's not evidence, is it?
No, well, it's not official. It has to be signed by the applicant.
Okay.
Not just picky, but, I mean, it has to be signed. It just.
I submitted the application. I didn't sign the permit, but I submitted the application and that was signed.
So I'd like to ask a question of Chris. Yes, ma'am. So my understanding, okay, so for those that don't know, I design homes here in Emerald Isle, do additions, all that kind of thing. My understanding is if you're doing less than 50% of the house value, you don't have to conform everything to meet the present standards of everything. If you are rebuilding exactly what was there, I don't understand why that isn't.
If it's not 50% damaged, you can repair it. The
Well-
deck was gone.
So,
That's my view on it.
so the 50% rule comes into play for various items. Floodplain, if the structure is located in floodplain. What were,
It also comes in effect with setbacks, because I've seen it with setbacks.
so what is before you is an application where there was a deck at one time. For whatever reason, there's not a deck now. Are non-conforming, because I'll read through this. Exhibit 5 of what I provided, which was a letter to, can y'all hear me on this?
So I read that part.
Yeah, so, well, I think it's important to make sure it's clear that Section 8.4 of the Emerald Isle Unified Development Ordinance states non-conforming structures may be improved or expanded, provided that any addition to improvements to or expansion of the non-conforming building must comply with the minimum front, side, and rear setback, as well as other dimensional requirements for the district in which it is located. And the addition to improvement or expansion may not increase the nonconformity of the structure. When nonconforming structure is damaged by fire, wind, act of God, condemnation proceedings, the structure may be repaired and restored to its original dimensions and conditions, provided that less than 50% of the structure at fair market has been damaged. So the literal terms of the code says only if there's an act of God, if there's a hurricane, if it catches fire, that's clearly states that if you can repair it up to 50% of the value.
And Mr. Chair, just a reminder, you have a pending motion on the floor. I don't believe the board's voted on to admit the application into evidence. It's been seconded.
Right.
I made
Is
the
there,
motion.
to what?
Who seconded it? You just don't need to say.
Okay.
If you would like him to sign it before you accept it, he's happy to.
I don't think that makes any difference, does it?
I would like to, if you don't mind, sir.
Okay. And with this, all those in favor of it, accepting that
Aye.
evidence?
Aye.
Thank you. Hand it down to our evidence holder. Yes, ma'am.
Just wanted to respond to the point that Ms. Manette raised, because that was my opinion as well. I don't know that fire, flood, wind, act of God, that this is not something that would fit within that, within those items. It's a deck that's suffered acts of God for 51 years.
Yes. That went through my
and
mind.
then, eventually did collapse. So I just wanted to
As I
make that
understand
point.
that ordinance, the intent of that ordinance is you can repair broken items. You can't replace them.
You can
Well,
repair
he
and
started to
restore.
repair it, but it fell down.
Right.
While he was trying to repair it.
Well,
So
you
If you try
can,
to start to repair a house and it burns down in the process,
burns down different than falling
100%
down.
gone. If it's 50% gone, you can repair it, but if it's 100% gone, you can't replace it.
right, this is basically a part of the house,
That's
though.
what I think.
It's-
To your front
It's
door.
part of the
It's to their
house.
front door.
Yes,
It's part of their house. That's what I'm saying.
okay.
It's actually bolted to the house.
Yeah.
Access can still be granted within the current ordinance to the front door based on the 3-foot egress. So he can still have access, he just can't have the front deck based on the ordinance. He can still build
I
a
agree with that.
3-foot
You can.
stoop and access with stairs per the
That
ordinance.
is where the measurement, the survey is very helpful for us. You don't need
know that-
16 feet to get access to the front door.
No, sir.
I don't know that
You only
the
need
survey-
about- you
The
only need
3 by
about 6
3
feet.
that was suggested doesn't even allow enough clearance to open the storm door.
I understand that. But you're asking for a 16-foot
He's,
encroachment.
Yes,
He's
sir. I'm
wanting to
asking
build
to
back
put
what
back
he's
what
got.
was there.
Right, but we can provide you access, reasonable access to your house with probably a 6-foot variance, which is much easier, I think, to get past than a 16-foot. That's where that survey, again, comes in, it's very important.
Can you tell me, just by chance, anyone, where is the setback or the right-of-way for DOT? Is that measured from the center of the street?
Not
No, sir.
necessarily.
No, so there's right-of-way markers. A
Yes,
lot of
sir.
times, the center line of any type of major thoroughfare jogs back and forth due to tons of different variances. Human error, one in Building 58 could have been off by 3 or 4 feet. So really measuring from the center line of any street doesn't really give you, it gives you a relative starting point, but it wouldn't give you an actual hard line to where the right-of-way should be. They will definitely take the right-of-way markers into consideration, but although they could be moved as well, we've seen recently where it appears that somebody might have moved one, which is not allowed under North Carolina General Statute, but the surveyors would go out and compute with various instruments and their experience where the corners of the property should be, and be able to do an as-built on your property and say, hey, you are, 40 feet off the right-of-way, or you're 30 feet, or however. It would be,
And what is the distance of the right-of-way, sir?
there's 100.
A numerical figure, what,
That's close to the end, or close to the Indian Beach side, so it's probably anywhere between 50, 60, maybe 75.
Yeah, so DOT has a variable right-of-way for NC 58. And again, it would be a surveyor that could tell us, we could look it up on DOT's website as well as GIS. But there's no standard for right-of-ways. They vary from 40 feet to.
so is that from
300.
left to right?
Yes, sir. That is it's based on a corridor that DOT.
Okay,
has.
so that's from shoulder to shoulder, not
No, sir,
necessarily?
that's right-of-way to right-of-way.
Okay,
There is a.
so the right side of the road to the left side of the road, that would be from right-of-way to right-of-way?
No, sir, it would be
Across.
beyond the road, to
For-
beyond the road.
For example, up where the food line is to the bridge,
Yes, sir.
that highway is all the way on the south side. It's a 200-foot right-of-way there. It's set all the way on the right-hand side, or the north side, to allow for another lane on the south side, which they've never installed. So that, there is no center line to measure that would define where it is.
So based on the provided plat that was recorded, I don't see a date on there, but there it's calling for a 60-foot right-of-way for Ocean Drive. The right-of-way stops at private property, back and forth, left and right. It's not really, it's not a, commonly misconstrued as the right-of-way line follows electric poles. It sometimes does, but it also doesn't have to. It can be inside, outside. Carteret Craven and Duke Energy have easements that allow their property, their overhead power, as well as Bogue Banks Water and all the other utilities require easements, whether it's a utility easement, overhead power easement, or what have you. But here, without knowing, exactly what it is today, when this plat was done, Emerald Drive shows a 60-foot right-of-way. And that's not something that could be easily measured on the road without having a surveyor, a professional, put a survey together and show us exactly what it was, back when this plat was recorded, what it is now. It's not something that a layperson, myself, or anyone else that's not a surveyor could go out and easily say, this is where your right-of-way line is.
Mr. Chair, just as a point of order for the board, and the witness and the applicant, the cross-examination of the question should be between staff representing the town. The board may answer questions from the applicant, but the board is not required to answer questions from the applicant. The applicant can cross-examine Mr. Seaberger, ask him.
Just trying to be helpful.
Yes, sir, understood. Just want to make sure you understand.
Nice matters.
Yes, sir.
So just to make a statement, all right, again, in my case history staff report, it did explain that not only myself, but also the town manager visited the site, found a North Carolina Department of Transportation right-of-way concrete monument. They do move for whatever reason, but that is the best available reference point, aside from the location of utility poles, for any staff to measure from. So measuring from that, that's how we determine the 30-foot distance from the right-of-way line or the front property line to the building front. Also note that you have, as part of Exhibit 2 in Mr. Hayes's email to Mr. Quick, a screenshot of Carteret County GIS map that shows the property lines, and it also measures the 30-foot that matches what staff was able to confirm on site. The 30-foot went to the building front.
Chris, can you confirm that the deck, that the pilings that they've got, or the brick that they've got currently, because I've seen it, is that matching what was originally in place? Is it exactly the same footprint, or?
I cannot confirm that.
Yes, sir.
I can tell you it does, ma'am. It's 16 foot out from the house. Again, I'm not a surveyor by any means, and I'm not trying to imply town staff measured incorrectly. I think there might be a side street setback, maybe from Raleigh. But again, 60 foot was what we went on from right of way to right of way. And just in my own opinion, we measured from the center of the highway, thinking that was the middle. I didn't take into consideration that that right of way could vary from the center of the road, left or right.
Well, let me get to a question important in deciding this. One of the things we have to ask is, do we have enough evidence to make a decision? Are we missing evidence that
Like we need a
would prevent us
survey.
from making that decision?
I think we need a survey.
That's what I think. I think we need a
We need
survey.
a survey.
So
To
we,
know what we're talking about.
we feel like we can't make a decision without a survey. Is it possible you can get us a survey in a reasonable amount of time?
Sir, I will tell you, it's reasonable for you to ask. I can't guarantee what their surveyors in this area, how backed up they may be. I will tell you, I would do
They're-
everything in my power to do it.
Yeah, they are 3 and 4 months out, from my understanding.
So, a reasonable time might be end of summer, Labor Day.
I I don't think I can make a decision without seeing an official survey with all this complication of where the actual line is.
Well, can I make one point, because I don't want you to make up your mind yet? If Mr. Quick had not touched the deck, not tried to just take some minor steps to make it more safe, and the next windstorm had come along and it had collapsed, then we wouldn't even be having this conversation, because it would have fit, y'all would have said, oh, well, that's an act of God, it would be within 8.4. You have the power right now to grant a variance, and it would be the same, it's the same kind of thinking as you already have an ordinance allowing us to do. So I just want to put that out there, that,
If it had collapsed before Chris, if it had collapsed before he went to get a permit, would he have gotten permission to replace it? I don't think so.
Not over 50%.
And if it collapsed in half and fell to the ground,
50% of the whole structure. Again, but this deck was an integral part of the house. So we're not looking at the entire, 50% would be 50% of the house and including the deck.
is that correct?
The way, the position the town would take on that is that the deck is the non-conforming feature. The house is not non-conforming.
But
The deck is non-conforming because it doesn't meet the setback requirements. So it's the non-conforming portion to which the section of the UDO applies that says if it becomes destroyed greater than 50%, you cannot rebuild it. If it had been less than 50%.
But can we confirm that that deck was there before he bought it? Again, I'm like, looking at the information, it was not on your stance that you pushed the deck out. You bought the house, the deck sat that far. If he's going exactly that same distance, I'm saying that's the hardship. It was not him. It was, he bought the house. That was the hardship, whatever the words. I'm probably not saying legally.
Yeah, I don't know if this is something that I can say as a Board of Adjustment member, but I feel like it's wrong to take away some of his property that he bought.
No different than 10-foot setback.
That way.
Mr. Chair, there is a provision in the UDO about non-conforming structures. To your point, now folks are required to build, 30 feet from the front line of the
Right.
property. So the idea about the 50% is that you can't you can only replace, you can only repair, you can't rebuild. So we are working within the constrictions of the UDO and what it says.
Right.
Fair or not fair, those are the non-conforming provisions. So the way to address that would be through a text amendment to the UDO, if the planning board, if you all as a planning board wanted to recommend that. But without that, we're dealing with the non-conforming provisions as they exist.
But so this house wasn't 50% damaged, so they don't have to conform to the UDO, right? You only have to conform if you have 50% damage that you have to.
It's of the structure that's non-conforming. And yes, the deck is attached to the home.
But the deck is his entry to the home.
I mean,
No, the deck is a deck. Entry to the
But
home could
that's
be a
his front
3-foot.
entrance.
that
It
is
could
his,
be rebuilt per the ordinance.
But that's his front
It
entrance.
might not be the same, but it can be rebuilt per the ordinance.
But we,
So were the setbacks different when the house was built?
Yes.
They're still the same setback?
The
So it
only
was
difference,
non-conforming then?
so the code only makes difference on when lots were recorded on the side yard setbacks. June 11th, 1977, that's specific in the code. Other than that, all lots are considered the same, depending on what zoning district they're in. This is an R2 zoning district, which does have the 30-foot front yard setback.
In my experience, I've been building decks in this town for about 30 years. I've built quite a few of them. And I've got a lot of applications turned down because they encroach. The existing deck encroaches. I can't replace it, I can repair it. I've dealt with that for a long time. I've dealt with other contractors that tore off the deck before they got the permit. Somebody calls me and says, hey, my contractor messed up, and now he says he can't rebuild my deck, can you help me? I'm like, no, I can't. It's just
There's still part of the deck attached to the house.
the band.
That's
That's not
not a
the-
band. I mean, it's a plate with hangers on it.
Yeah, that's the house, that's the deck band attached to the house. That is, less than 50% of the deck. If a few decking boards got broke and you wanted to replace them, you can repair that deck. But in my experience, building decks in this town, that get permission before you take them down, because you likely can't rebuild them. It
Well,
happens
that
all the
wasn't
time.
what he was trying to
wasn't
do.
to
He
take it
wasn't
down.
trying to
No,
do
but
that.
it's gone.
Yeah, but
Whether-
he,
If a car ran into it, tore it down,
but he didn't try to do that without a permit.
that, in my
Susan,
opinion, my experience, that makes
How
no
do you know
difference.
that? How do we know the next person doesn't just say, oh, you know what, I'm gonna tear it down, and then ask for forgiveness?
But,
We have
but they
paperwork.
just said
But
that
he-
they had paperwork.
He was also doing work without a permit, and any structural work in the state of North Carolina requires a building permit, no matter if it's $1 or 100,000. A structural permit requires, a structural act to the deck. Replacing
So
four
in
by
other
fours
words,
is not a small
So in
task.
other words, he should have gotten a statement from the permit guy that told him, that it was, to repair it, he didn't need a permit, is what you're saying.
That
He
wasn't-
should have
No,
that
it's-
so
That
that
was
he
issued
could.
by the county, not the town.
Any
Correct.
minor work is, like what Kenny's trying to say, Chairman, is deck repairs, which is, a few boards here or there. Any structural members, any vertical columns, any bands, that's not minor work, that's major overhaul.
Which can be
I
done
s- I-
under the 50% rule, but
I look at it as, that's his entrance to the home.
Right.
That's part of the house.
all right, we can.
And the
we-
town's looking
we
at
can
it
get it.
differently, the UDO looks at it differently, but
We can get him adequate access to his home without granting a 16-foot variance in the setback. You can do that with probably 5 or 6 feet. And
But you're-
Make it very,
taking away what
You
he.
can't even open your
bought.
door.
we're not, nature,
The town
Okay,
is
that's,
taking away
that's
what
the
he
same thing when we
bought.
voted for the 10 foot or 15 feet for the fire thing, like, it's the same thing, we're taking away land from people.
Yeah.
So it's the same thing, so if we're gonna vote that way about the fire department and all that, like, I think we have to be fair to everybody. So I find it interesting that we're fighting one way for the people on Coast Guard Road, but in a different area, we're like, no.
we're
So
not-
I'm just saying, it's frustrating to
We're not-
me,
we're not
because I
even-
feel like everybody's all in for, don't take my land, but over down that way, oh, we can take your land. Like, he's just rebuilding what was already on his house.
have we
Yeah, he's
established
going to the
that,
same footprint.
have we established that it was not encroaching when it was built?
I don't know.
It doesn't-
I'm just saying, he bought the house,
I
it
don't-
looked like that,
I
he's
don't
just
think
trying to
this-
repair it.
In my
Sorry.
opinion, it doesn't matter because that's how the house was when he bought it.
That's what he just wants his same house, and he wants to make it safe.
When I bought my house, my storage building, with a slab garage, it was big enough as a garage, on my survey, it showed it encroaching the side and rear setback by 1 foot. It showed it on my survey. Basically, that said, it's there, you can keep it. When that tree fell on it, I couldn't rebuild it in that same place. That's the way it happens sometimes.
And that's where I think it was, you should have been allowed to rebuild that. That's what I'm saying.
If we'd been on the planning board then, it would have been different.
I didn't build it, it was built.
I think
built made.
if it was already, if that's what you bought, you should be allowed to rebuild that.
Yes.
That
And
is
the
my-
deck
I
that
don't
is
know if
there, it's
that's a
not like
legal
hanging out in the
opinion,
road.
But that's
I mean,
my opinion.
I don't know.
It was noted.
We would have to do, like our attorney said, we'd have to do a lot of text amendments to the UDO to make that truthful.
But you certainly understand that opinion. Again, the UDO, as it exists right now, provides that if the damage is over 50% to the non-conforming portion, it can't be rebuilt. So if that is the desire of the planning board, to change that, I mean, we've got to deal with what we have tonight
Well, and
in
it's
front
to
of us.
the.
But if you want to change that, you would need to propose a text amendment to the UDO.
And that's not Board of Adjustment, that's Planning Board.
That's right, that's the planning board. The planning board would need to present that text amendment to the UDO, removing the non-conforming restriction. But as it sits, that is the existing restriction to the non-conforming.
So
of
you're
We're not
basically-
arguing with you guys.
You're basically saying that that we can't do anything to
Correct.
help him.
We're not
We
arguing
can't.
with you. We're
Right.
saying that
We can't.
today, based on
That's-
the ordinance,
But
And without a
It's just
survey.
frustrating us.
But
See,
But I-
we're frustrated. We're
yeah,
frustrated.
what I'm just saying, I mean, I understand
Frustrating.
what you're saying, and I
Follows the
understand that completely, but
Yeah, we don't get to have opinions.
There isn't any, so he's
But
out
you
of
can
luck.
grant a variance. I mean, you do have the authority to grant a variance.
Yeah, but
It's
what we're
It's gotta be
saying,
factual.
Factual
We
and
can't use our
hardship.
opinions.
yeah,
You
we,
have standards that.
We have
are
standards.
The basis
Yeah.
for granting
Yeah,
variance.
this is,
And
you know, you're a
can-
lawyer, you know.
That's why it's important if we have the
Yeah.
survey.
Exactly.
don't
We had the
think
survey, we had the survey.
and the
I don't
survey
think the survey
could,
would made any
the,
difference.
I
the
don't
thing that
know.
I'm seeing right now
Standard.
is the Emerald Drive on this plat, when this lot was created, was shown at 60 feet. That right-of-way, based on non-official measurements that I'm using, is showing it at 80 feet. So that means each side lost 10 feet at some point from when that plat was recorded until today. Maybe if that date was 1999, 2000, whenever, you could have more of a hardship stating that the deck was built in compliance when it was permitted, and then present it to us stating, hey, this is a real hardship. Because right now, we can't go on an opinion of a hardship. It doesn't qualify, to my opinion, in the general statute of North Carolina, the certain criteria that requires hardship for a variance to be granted. So if we get a survey, we can see exactly what the original right-of-way was and where it was located, and then what the current right-of-way is, and then maybe we can either grant a variance based on actual hardship with actual fact, or maybe we turn it down and we present a text amendment to the commissioners that state, you know, hey, we need to relook at the 50% rule and how, you know, whether we take out ingress egress to existing structures as an option or whatever. That's something completely different than the Board of Adjustment. But at this point, I feel that we don't have all the data that we need to successfully grant a variance.
I would like the survey.
Um,
And give me more to stand on.
You have not been sworn in?
I just have a question.
You can't say that.
No,
No, it's already,
You can't,
you can't.
But the inability to reach the front door is not considered a hardship?
No, in Emerald Isle, we have a 3-foot allowance for uncovered structures that can encroach by permit, by UDO allowance, that would allow ingress egress into the property. And I'm sorry, this would be Chris's.
yeah, and I'm gonna get back to this.
I understand.
Let's go. Are there other materials not in evidence which would prevent y'all from making a decision tonight?
Yes,
Yes. And mostly it's a survey,
survey.
and perhaps actual right-of-way data. So I suggest that we recess the meeting until we get the additional information. Because I don't want to vote no on it without that information.
Correct.
Mr. Chair, may I suggest that instead of recessing this meeting, that you just table the matter until the next
Table?
regularly
Same-
scheduled meeting of the Board of Adjustment? Or
I don't want to vote it down. I want to leave it open until the applicant can get us more evidence.
Make the appropriate thing would be to request, I don't think you can require a survey from the applicant, but to request that the applicant provide a survey to support the request for a variance. They will or will not, depends. But table the matter until such time. Is there a time limit on when they've got to hear this under a variance? Do they have an outside time limit?
Not that
Under the UDO?
we've heard it already.
With that said,
So can I make a motion to request that, or can we just say to request it, or how
You don't,
to be?
I think the general consensus of the board sounds like the request of the applicants is to have a survey to understand the variance requested and how much of the variance, since the issue has been raised, of how far the setback really is, how far the encroachment is. So that's a request of the applicant. You don't need a formal motion for that. I think they understand that. Do y'all have any questions about that?
There's not going to be a timeline. I mean, of course, I'm going to do everything I can to make this happen, but based on the current environment, this could be 160 days out. I don't want time to expire or to look like I'm non-compliant based on the willingness and ability for someone else to get out there and do the job.
With any luck, I could be wrong on that, but that's what I've been dealing with, was 3 or 4 months with my clients.
Well, it's that way in Wake County.
We appreciate you being really open though, and like, just coming forward about all this, because
We don't want to make a decision against, my opinion, I agree with them. I want to grant you the deck. But our facts, we have to go by facts.
We
The
don't,
facts
we
is-
don't want to turn you down. We request that you get us a survey so we can make a competent legal decision.
That's not a problem. I will,
Yep.
I'll get on it forthwith. Now, how do we go about, I think there's a month waiting list. You have to be on the agenda a month ahead of time. Is there any?
Is there a way to make
or-
a special
We can-
concession to
If we can,
whatever?
we could probably get together a special meeting.
That would be grand.
I can't promise when it would be, or, you know. We got,
Chris is, I just,
Hold on, let's let Mr. Chris.
time limit.
We talked about the normal procedure first. There's a deadline for submissions for the next BOA meeting, which Mr. Seberg would be on what day?
It'll be the 24th of this month for the June 24th meeting.
So there wouldn't be any reason to call a special meeting if we can fall within the parameters of the normally scheduled meeting. And you could do that by communicating, Mr. Seberg, with the applicant to see if the survey has been completed and can it go on the agenda for the following month's meeting.
There's not gonna be a deadline
It's
though,
a-
that he has.
Should
in
we
case
put a
he- In case he can't get the site plan in time, there's not a deadline
Should we
cut off.
put a deadline just so that
I think there
they have to
shouldn't be.
follow up with us? Just so that it's a never ending, or how should we?
I'm told that there's no UDO deadline for
Uh,
a variance.
I am not seeing, I'm looking online.
So we just
of
table
our
it until which
UDO.
time they submit, and then it just meets the next meeting?
And if something about that, if we look at that issue and find something otherwise, we'll communicate with the chair and suggest that this board convene and talk with the applicant, and so you can make a decision within the timeline. I mean, really, the issue is if the variance is not, well,
Yeah.
We could always,
it may need
We
to
won't
be
know.
granted within a certain time period. I'm not aware of that, but,
we could always open it up and table it again, even if they're not here, correct?
well, sometimes the UDOs or LDOs have provisions that say they must be ruled on within 180 days.
Yeah.
But I'm not aware of that, and the planning director's telling me he's not aware of that. So I don't think you've got a time frame there, but we'll look and make sure, because that would typically say, those provisions would typically say that if they're not ruled upon, then they're granted. So in that case, this board my recommendation would be that this board reconvene and make the decision based on whatever information you have available for you, so that the applicant can have the benefit of your substantive decision. With that being said, getting a survey as soon as possible is the best course of action here. So this matter can go back before this board at the earliest convenience. And if the variance isn't granted, then the board will at least rule, and perhaps something else will be granted, or, you will at least know what you can build, even if it's the 3-foot stairway.
and it sounds like we can convene much quicker than you can find a surveyor. So, once you get it surveyed, we'll be able to convene pretty quick. But if we don't, without that survey, we cannot make a competent decision in your favor. So we,
I have no problem with that.
Not this.
so.
Thank you.
Thank you.
I make a motion to table the request of variance application until further notice and further data from the requesting party.
A second?
All those in favor say aye.
Aye.
Motion is passed. The meeting is tabled. Thank you, sir. We'll try to work with you.
Appreciate your efforts.
Anything else to do on that meeting?
That's Mr. Chair.
It's tabled,
The
and now I can gavel in the,
The matter's been tabled, so at this point, you can ask for a motion to adjourn the Board of Adjustment meeting.
okay?
I'll make a motion to adjourn the Board of Adjustment
We have a
meeting.
second?
I'm sorry.
Second.
Just, as part of this adjournment, please take a 5-minute break so people can use the restroom.
Oh, great.
Okay. Can we adjourn it and then take a break?
Yes.
We have a motion to adjourn. All those in favor say aye.
Aye.
Adjourn. 5-minute recess before we start the planning board meeting.